Tabitha. Thank you for sharing your wealth of knowledge and insights. So, without further ado, welcome, Tabitha, and thank you for presenting today.
Thank you so much for the invitation, you guys. Thank everybody for being here today. I saw that there's a range of experience with criminal records. And I just want to say here at the beginning, I invite a lot of people to this space as well, not necessarily attorneys. I invite people who might be pro se or who might be advocates. So I'm kind of be teaching this CLE today from two different perspectives. I'm going to be teaching it for community members or pro se people, and I'll also be teaching it, for attorneys who would like to incorporate this in their practice or just become familiar, and then just kind of a refresher for, I know that there's several people here who are very familiar. So we're just going to jump right in because it's a pretty long presentation. But again, if you have a question, go ahead and raise your hand and you can ask it wherever we are because it's kind of a long presentation. I don't like to hold questions until the end. So just ask a question when you have one. All right, let me see how to click my click. Here we go. Okay, so we're going to start with just talking basically about what is criminal record sealing. Criminal record sealing in Arkansas always make sure to kind of explain or make sure that the person knows that it's criminal record sealing in specific because that's what the statute allows. There's a lot of things that people want to seal sometimes that are not necessarily allowed in the statute. I tell people to go ahead and try it. These are usually like orders of protections or different kinds of cases, but specifically what I'm talking about is criminal record sealing today. And so what that is basically is a restriction of access to a criminal record. A lot of people still call it expungement. We do not expunge in Arkansas. It used to be the law many, many years ago, but I just want to be clear for people that even if you call it expungement, it's not going to be expungement in effect. Expungement means it's gone. It doesn't even show up on your ACIC criminal record anymore. But there are some records that people who have gotten expungement, it's kind of a mystery. But as of right now, 2026, and for many years in the past, there's no expungement in Arkansas. So we're sealing your criminal records to law enforcement use only, is what it will say once your record has been sealed. So it can basically still be seen by the following list. Law enforcement, that means police officers, sheriff's deputy, anybody in the law enforcement spectrum, state police, anybody that, when you're getting stopped and they're running your background, that's what they're looking at is your ACIC report, basically. Prosecutors can see it. So if somebody seals a case and has a case in the future, they'll still be able to see, prosecutors can see the whole record. ACIC, of course, can still see the record. ACIC is Arkansas Crime Information Center. That is the state agency in Arkansas who compiles a criminal history report or the criminal history record. It's the official record. There's sometimes a little bit of confusion between a state police record, getting a background check by the state police, and ACIC. State police has a cost. The last time I know it was like $25 or $30 to run those background checks, and it's not at all going to help you with what you need. So what you really want is your ACIC report, and I'll talk about how to get one of those. Those are free. But ACIC will still be able to see the cases. Criminal justice agencies in conjunction with employment application, that means really police officers and anything that has to deal with law enforcement. So if you have a case that you have sealed and you want to be a police officer, they're absolutely going to be able to still see that. Polygraph examiners, private agencies, that doesn't come up as much, but I leave it on there so people will know that it still can be seen in some ways by those type of people. And then state agencies, even though I kind of went over it, I like to over explain that the criminal record doesn't just go away. Some people think that it'll never pop up again. Once they seal it, they're done with it. They'll never hear about it. But that's not the case for state agencies. So if you want to work for a state agency at some point, and that's anybody that's considered the state, that and basically anything with a license. So teachers, wanting to work for the Department of Corrections, nursing board, anybody that has a state job or that has a state license associated with the job, they'll also be able to see it. So that's the thing to know about what sealing records means. All right, I'm just going to go over the process briefly. What I'm talking about for the most part today is the judicial process. That means sealing a record through the courts. You're asking a judge to seal it. The alternative to that is through the executive clemency process, and that's asking the governor to seal it. And you have to go through that process under certain circumstances. And I'm going to cover all that today. But right now, I'm going to talk about the judicial process, where everybody starts, or where you want to start, whether you're sealing your own case or you're taking somebody's case as a client. You want to work up your case, and that means to prepare your file. There's a lot of stuff that you need to know to draft these documents and to know about the process so that you're doing everything correctly, so you'll have the right outcome that you want to have at the end of this. So when you're working your case up, you're going to research and gather all the information to determine eligibility. I never, never, ever, I listen to what people say, but I never just take it and go with it. I also always do my own research and investigation, which starts really with their ACIC report. ACIC report, it's an authorization form that you will send to your client. They will sign it for a notary. You'll send it into ACIC, and they will mail you a report. And there's also a way that you can go up there and get a report from in person, and I'll talk about that as well. But you want to start with ACIC report because maybe people don't remember what they had. Maybe people have more than they're telling you or less than they're telling you. You just want to start doing your own investigation. You're going to need the sentencing order from the case that they're talking about that they want to seal. And for me, I like to get on the front end or start having the person or client start working on getting a probation release. How to get a probation release or a parole release is supervision release. So you're going to need it to show that the case is finished. You were released from probation, you're released from parole, you're released from supervision. It shows that you paid everything and that you finished all parts of your sentence. And I'll talk about how to get one of those. You might need your probation conditions. A lot of places have them online these days. A lot of places don't. And then you're going to have to, as part of working your file and determining eligibility, you're going to figure out which forms that you're going to need to draft. Okay, so the next step after you get your file or get everything that you need, all your paperwork together, you're going to start drafting your petition in order. That's the next step. The next step after you've drafted will be to file. That means you're going to file your petition. You're going to file a proposed order. In most cases, you need to provide the order, even if you're pro se. If you're an attorney, absolutely file a proposed order when you file your case. And then in a lot of cases, especially in Pulaski County, Adrienne Griffiths is doing record sealing for the prosecutor's office in Pulaski County on the felony level. It makes it easier for her. She's going to come back most times and ask you for a probation release. So you can either file it in the beginning with your case, or you can wait 30 days for her to say, hey, can you give me a probation release? So I say go ahead and file it in the beginning. When I file it, if you're an attorney, I file those under notices, under the listing notices, and I put probation release or proof of discharge or something like that. So I like to shortcut it like that because that helps the prosecutor come up with their answer faster if they see that probation release, in my mind anyways. And then so after you file all of that, if you're filing it on your own, you're going to take a copy to the courthouse. They'll help you file it. And then you need to send a copy to the prosecutor. So they'll know that you have filed a case, and I'll talk more about that, but you basically need to email it to them or drop it off or mail it to them. All right. The next step in the judicial process is going to be a little waiting period. You got usually 30 days to wait for a response from the prosecutor. Your response options are objection. That means they found something wrong. They have a problem with you sealing your case for some reason, and then you'll go to a hearing. There's a no objection, and then in most cases, the order will be signed without a hearing by the judge. And then there's also a no response. So it's been 30 days, you haven't heard anything, there's nothing on Court Connect. So in that scenario, I would advise you to go ahead, whether you're doing it pro se or you're an attorney, go ahead and call the prosecutor's office and say, hey, filed this case for myself or so and so. Here's the case number. I filed it about 30 days ago. I'm calling to see if I can get a response on that. And usually they'll go ahead and file one pretty quickly after that. If they refuse to file, which I've had very rarely happen, we'll talk about strategies for that in the presentation as well. Okay, so after you get a response, I'll talk about hearing later in the presentation if you have to have a hearing. But if there's no objection, you'll get the order signed by the judge, and that's where your case is ordered to be sealed. But I want you to know, please pay attention, you're not finished there. because you have to make sure absolutely that this is the important part is email a copy of the order back over to ACIC or make sure they get a copy. You can email it to them, you can drop it off to them, you can mail it to them, but make sure they get a copy because even though the court clerks are ordered to do it, I've had some clerks that don't do it or they'll wait 30 days and send them in a big batch. You know what I'm saying? So it's important for you as your pro se or as the attorney representing somebody to get it back over to ACIC. Make sure it gets sealed at ACIC because that's when the case is sealed. That's when it's not going to come up on the background or whatever you're trying to do is sealed at that point. So ACIC has 30 days to get it sealed on their end. It usually takes about 2 weeks. It doesn't normally take the whole 30 days. So what I normally do is I give them a call and say, hey, I'm representing so and so. Has that case been sealed yet? And they'll look at it and they'll say, yeah, it's been sealed yet, or it has not been sealed yet. When it has been sealed, you're going to want to request an updated copy of your ACIC report. I like to look at it myself. I like to lay eyes and make sure everything has been done the way it should be done on my cases. So this is the way I practice, and this is the way I would advise everybody to practice if you want to do a great job. So you want to look at the ACIC report, make sure it looks good on there, make sure it's been sealed, it has all the proper, and I have examples of this later in my presentation. And then you want to keep a copy of all the documents for your files. You want a copy of your petition that you filed. You want a file marked copy of the signed order. And then you want your final ACIC report to show that the case has been sealed on their end. All right, that's a run through of the process. Let me get a time. All right. So what you want to tell your clients or what you want to know before you get started, again, criminal records are only restricted by state agencies only. This is very important to know because what it means is if there's a private background check company, they may or may not have updated their files. And so this is something I come across a lot of people that practice in this area come across. So the state won't be able to see it anymore, but this private background check company, it showed up. So what you have to do at that point is kind of dispute it. You have to contact, if it comes up on your background, then I would ask the person who's running the background check for a copy of whatever they're looking at, a copy of the report, and that'll show you what company is running the background check. And then you basically have to contact them, let them know the case has been sealed, and sometimes you have to provide a copy of the order or just proof that it's been sealed for them to take it off of there. So, sometimes at that point it's not helpful because it's already been seen, but I always tell people to just advocate for yourself. Like, hey, that's been sealed. Can I still be considered for this job? Can I still be considered for this apartment? I provide them whatever they need, but that is an issue. And again, it's the difference between a state agency that keeps the background and a private company that keeps the background. The judge can only order the state different clerk's offices, ACIC to seal the record. The judge can't order the private background checks and stuff to do that. So you have to realize that might happen if you get a client that comes back and says, hey, this wasn't sealed, it came back up, then you might be dealing with a private background type of situation. This presentation I give a lot, so there might be some old law, but just for people to just know the new law. Since 2019, there's no filing fee. Before 2019, there was a $50 filing fee per case number. So no clerk should be charging to file petitions to seal at this point. And other important things to know is that sealing a case doesn't have an effect if a name is on a registry. So it doesn't remove anybody from a registry. And those are normally child or adult maltreatment registries or sex offender registries. There's a different administrative process to be removed from those registries. And normally, in my experience, the judge wants to see removal from the registry before the case is sealed. But you can do it either way. Try to do whatever way, but the sealing the case doesn't affect the registry. I just want people to know that. And then a lot of people think you need to seal your record to vote. That is not the case. I wish I had a whole slide I could talk about this for the whole hour. But basically, if you want to vote, you just have to be off of supervision. That's parole or probation. You get the release document that I mentioned earlier from your supervisor. It doesn't have to be from the officer who supervised you. So if you came off of probation 10 years ago, that officer is gone now. You just call the office where you were supervised, whatever county it was in, and say, hey, I need a probation release. It doesn't have to be from who supervised you. So it can just be anybody in that office and they'll sign it for you. I wish I had one to show you, but it'll just be a form piece of paper. They'll type your name in, the case number, they'll sign it, and it'll say on there proof of discharge or probation release. So you'll take that document and register to vote at your county clerk's office, county clerk. And so if anybody has problem register to vote after you've been released from supervision, please call me about that because I will look into it for you. I'm happy to look into that kind of stuff. All right. So another thing to know about sealing records. So here's what the law legally says, what you can do, what a sealed record does. You can state without legal repercussions that there was no conviction of the crime or the underlying conduct. So that's basically on employment applications, apartment applications. Have you ever been convicted of a felony? If that case is sealed and there's no other cases, um, then you can legally put yes. Okay, I see there's a question.
Yes, there two came in. So one
Oh, okay.
asked if a person has a felon case and gets sealed, does that restore their gun rights? If not, is that a different process?
Yes, and I'm going to talk about that more, so I will hold that
Okay.
until later in the presentation, but I will discuss that specifically.
Some judges use a specific order for orders entered pursuant to Act 346 to clarify that the sentence is pursuant to Act 346. Do you have a sample or model proposed Act 346 order that we could potentially provide to other courts that don't have or don't use a specific Act 346 order?
Yes. So according to the law, ACIC is the keeper of the forms. You have to use forms for this process. Some people don't, but the law says that you should. The entire record sealing law, it says that you're supposed to use these forms that ACIC creates. So yes, there is a form, and I will give the website and direct you where to find those forms in this presentation. Good on questions? Okay. So, I think I misstated when the question came in. So if you have your case sealed, you can mark that you have not been convicted on employment and housing applications. Okay. So, but that is got to be very specific. Now, if you got one case sealed and you got one case that's not sealed and they're both felonies, you can't mark that. So you have to make sure that you've got all your cases sealed that needs to be sealed. And I mean, they're getting really tricky with questions these days. They can ask, I've seen some questions ask, have you been convicted? I've had seen some cases or some applications ask, have you even just been arrested and not convicted? So you just need to make sure that everything is sealed properly all the way through ACIC if you're going to be marking that you've not been convicted, because that's really what this is allowing. Okay, and so if you're practicing this, what you want to ask your client is you really need to understand why they want to steal their case, and I mean get to the bottom of it, because they could be telling you, I need a job, but it could be like a gun rights situation. So you're not going to be in the same. You're all paths don't lead to the same outcome, so you need to know what the motivation is behind why they're trying to steal their case and dig into it. You need to know if they had felony convictions in other states or federal convictions. And then you need to know if there's any felony convictions in other names or aliases. So that's some things to think about on the front end of the case. Okay, I bring this up now. This has been in the news a lot this election cycle in Arkansas. Act 450 of 2021, it prevents someone who has pleaded guilty or no contest um, of a public trust crime from filing, running for, or holding office. So you can't file to be a candidate, you can't run for office, and you can't actually be elected and hold the office if you've been convicted of a public trust crime. And all the way at the bottom, you can see a public trust crime is any felony. And then there's some constitutional issues about notorious or infamous crimes and things like that. But this is what's knocking a lot of people out. A lot of people in the news cycles have been different misdemeanors, but this is getting people too. So, a full pardon, and then you can read this in the pardon application. It has some instructions and it gives some information, but a full pardon will reinstate the ability to run for public office in Arkansas. And these are the lists of Arkansas because I get a lot of questions about, well, so and so president is a felon, and how does he? There's a specific list of offices that it identifies in Arkansas. So those are constitutional offices, county elected offices, and elected office in a municipality, city, or township, and other political subject. I mean, this is city council, this is mayor, this is school board. So it absolutely affects who is eligible to run for office these days. So I put that out there because that is kind of an update. It's been on the books for a little while, but it's new from some of the presentations that I've taught. Okay. So this is a list of what you need to kind of get started. Again, this is all the stuff I identified that you need kind of in your case file. You need the list of charges or convictions that you're trying to seal. You need what court of the disposition. So where was the person sentenced or where did they go to court? You need to know the date of the conviction or disposition because the disposition is not always a conviction. It's sometimes a null prize, a dismissal, acquittal, something like that. You need to know what the sentence was, so whether it was probation, parole, you need to know if there was fines, you need to know if there were classes ordered, public service, all of that stuff. You need to know the full extent of the sentence. You need to know the date that the sentence was completed because that's going to do some charges can't be sealed until a wait period, which I'll talk about. You need your proof of discharge or supervision release. Some people call it different things, but I have stars beside it because that's been super helpful these days. When I first started practicing, I didn't have those as much, but now they're absolutely critical. And then other convictions or criminal history, and that's where the ACIC report comes in. Now I'll tell you this, ACI, everything's not on ACIC, everything's not on Court Connect, but you absolutely need to look at both. So you run yourself or your client through Court Connect and you do it by first name, last name, and date of birth is the best way to get who you're looking for. If you have a county, a specific county they were in, that might narrow it down even more. But I would say run a general search as well so you can see if they have anything in any counties that come up on Court Connect. I run into that a lot. I'm in Southeast Arkansas, and for some reason, some clerks, some cases, some felony cases are on Court Connect and not on ACIC. So you definitely need to look at both. Okay, how do you get the information that I just named? You get your judgment and your disposition or your sentencing order or your docket sheet. If it's a misdemeanor, they call them docket sheets in district court. You get those from the clerk's office or the court records office in the court where you were sentenced or where you went to court. Where you get your satisfaction of probation, I keep saying probation, but it's probation and parole. You get it from the probation or parole office where you were supervised in the county. And again, it does not have to be directly from the officer that supervised you. Anybody in that office can sign off on a probation release. All right, these are the steps on how to get your ACIC criminal history report. This presentation will go out to all attendees, so you'll be able to see these links and stuff. I took the hyperlinks out from the presentation, but you can copy and paste, I think. So here's the forms. They changed it used to be acic.org, but now they're all on the Department of Public Service website. So you'll go to this DPS website. acic.org doesn't work anymore. There's a link. It says authorization for review. You're going to click on that, print it out, and then fill out the form, get it notarized, and I email all of mine to ACIC. There's a mailing address and a fax number on there. I have found that though the fax number may work or may not work, and then when it doesn't work, it doesn't work for an extended period of time. So you have faxed in your ACIC report and your authorization. You're looking for a report, and that fax machine has been out for 4 months. So what I do is I email all of my authorizations. I get my client to fill it out and I get them to turn it back to me because I like to receive the reports myself. So I email it into Miss Susie Clary. She's the person that emails all the reports out at ACIC. I've also been told to email them to acic.criminal.history. And that's like when Miss Susie was out on vacation, but when she came back, she was like, "No, just send them to me." So if you want to be safe, you can send them to both, but Miss Susie is the one that handles those reports. She's going to print them out and mail them to you. And yes, they mail them. Otherwise, the only other way you can get it, they don't email them to you anymore, some kind of internal policy. but you can have your client, if they live in Pulaski County, if they're going to be in the area, they can go up to ACIC and they'll print off a report for them in person. So that's another way to get it. Um, I have some stars on there. It says no report for no charges. That means if you turn in an authorization and you don't have any charges, they don't send you, they used to send you a letter that says, hey, this person doesn't have any charges on record. For some reason, they stopped doing that. Now they don't send anything. So you'll have to call and be like, hey, I didn't get this report. And they'll be like, oh, there's no charges for that person. Now, last time I talked to Miss Susie about this, she said she was going to try to come up with something so that people aren't just sitting there wondering, but you might have to check up on it because I've have several people, they know they have a case. It's on Court Connect, it's not on ACIC. So you might just have to follow up on that. Here's the ACIC form. Basically, what you need to fill out is the top. They'll fill out the top blank. This is what I direct my clients to do. Fill out the top blank, fill out the box in the middle on the left, and sign in front of a notary. The notary is not going to notarize it if you've already signed it. So you need to make sure it's signed while the notary is watching. Take your ID for the notary. The important thing for attorneys or advocates in this situation is the blank in the top paragraph that says type or print your name as of the designee. If you're an attorney representing somebody, your name and your phone number needs to be in that blank, or ACIC is not going to discuss the case with you whatsoever. If you have in a situation where somebody has already gotten their ACIC report and they're giving it to you, that's fine. Just have them execute a new authorization with your name on file because more than likely you might have to call, like I said, if you're calling to see if it's been sealed already, or if you're calling, if you have a question about your report, if your name is not on there, if they're not going to speak to you. And then you can have it mailed to wherever you want. I have some clerks. Oh, let me not be too specific. I have some people that don't want to notarize these for people if the same person is not getting the copy of the report, but that's absolutely not what it says. It says name of requesting party or designee. So you can get the report sent to you as the advocate, social worker, attorney for this person, but you might have to battle a clerk that doesn't have great reading comprehension. So, or if that's the case, just send them somewhere else to get it notarized because I don't like fighting that fight with people. What am I supposed to say? Okay, but make sure if you're representing somebody to put your name in there as a designee. That's the important part. Generally, I've been told that these expire in 3 years because some people want to know, like, I don't pull people's records when I close your case with my office. I'm not playing in your criminal history anymore, but I've been told that they expire after 3 years. Okay, so when you get your ACIC report, it comes in the mail. It takes about a week or two to come in the mail. I then send a copy to my client for review. If there's any questions, well, they look it over. They might have questions. It might be exactly what they thought. It might have more or less than they thought. So when you're reading an ACIC report, it's important to know a couple of things. They're listed by arrest. So that means arrest number one, arrest number two, and so forth and so on. And each you sections are supposed to be reported by each agency. So what you're seeing on the screen is it was reported by Pine Bluff Police. This shows an arrest only. It doesn't have any disposition for the case. It's also important to know that sometimes there's mistakes. They're not always accurate. The record's not always complete. So this arrest here, excuse me, looks like it was just an arrest, but then you go on Court Connect and you find this case. So you have to you have to make your file and you have to include all the information on there. And I just don't think you can do that without an ACIC report. And so I always start here and I explain to my clients, I said, I pull your record because they could have mistakes. It could have literally somebody else. It could have Tabitha Lee on your record because they made a mistake somewhere. Administrative clerical errors, they happen all the time. So you always want to look at that. And then I've had this come up sometimes where you've had like a sibling or a cousin use your name when they got arrested and you didn't know about it. So I don't know what that was from. That wasn't me. And then so you might have to do some investigation into the record. So you always want to know what's on there. You always want to know what police are looking at. You always want to know what prosecutors are looking at. Don't put yourself in a position to be at a disadvantage because you didn't pull an ACIC report. You don't know what they're looking at. And then it says it may include information that's not on Court Connect. Again, some cases are on Court Connect, some cases are not on Court Connect, some cases are on ACIC or not. You need to look at it all to see what you're dealing with. This is just another example of an ACIC report where you can see like okay, so the first information was reported by the police department. Then you have some disposition information that was reported by the court. Every agency is responsible for reporting their own information. And then just a little notation to see that sometimes you can see where it was filed as an aggravated assault felony, but it was reduced in the end. The final charge ended up being reduced to a misdemeanor. So you can get all kinds of information from these ACIC reports about the case, or again, it might not be on there. Here's another example, and this is what an ACIC looks like on a sealed case. So you can see it says name, and then under that it says this ATN. ATN is arrest tracking number is sealed, restricted to criminal justice use only. So when you're reviewing, either in the beginning or in the end, you can see where you or your client may have had some cases sealed already. And then when you get the report back after your case has been sealed, this is what you're looking for. And then on the bottom, the very last line, it'll say sealed per court order. And the first date, 11/22, is the date that it was signed by the judge. And then the second date, 12/13/10, that's the date it was sealed by ACIC. So that's what you're looking for to make sure the case has been sealed properly. You can also see this was an interesting case. This was a misdemeanor that was sealed under First Offender Act. I don't believe in that, so I went back and I amended. I asked this judge that had sealed this case already to amend that to just seal it under a misdemeanor. And my client, we ended up getting another case sealed under Act 346. I know everybody might not like that, but I'm sealing records and that's what I do, so I like that a lot. Okay. Choosing the correct petition in order to prepare is important, but it's pretty straightforward. If you just got an arrest and no conviction, you're going to seal it as an arrest. If you got a misdemeanor, you're going to seal it as a misdemeanor. The other acts are, I'm going to talk a little bit more about how to figure out if you were sentenced under again, we don't expunge, but we call them expungement acts or expungement statutes or record sealing statutes, and those Act 346, Act 531, or Act 1460. You can also seal null pros cases, dismissed cases, and acquitted cases. That's a separate form. And then you have PAT court, which is drug court. Those are separate forms. And then you have a separate form for basically possession charges that are kind of confusing that nobody uses. And here's the website. So for the person that asked about forms for Act 346 and the order, this is the website you're going to go to. And when you get to this DPS website, it's going to look like this. Okay, so when you get to this page, it has all of the names of the documents that you're looking at. So petition in order to seal felony under Act 1460. If you got your felony, you're trying to seal it under 1460, that means you didn't get 346 or 531, you're going to go to 1460. The next is petition to seal order of misdemeanors. So you're just going to go down that page and you're going to find it has a petition and an order for each type of case you're trying to seal. So if you go down, Act 346 is a little bit lower on that page, but it'll say petition in order to seal records under Act 346 of 19, I think it's 1973, something like that. And then another thing that you can see on this page, I don't know if I would trust it because ACIC is by law ordered to do this ACIC stuff. The governor stuff is a different office under different supervision, but there is a link here at the top if you see it, instructions and applications for a governor's pardon. I didn't check it before this presentation, but I would go and I say this later in the presentation. Go ahead and Google Arkansas pardon application to pull up the most recent pardon application because they do change from year to year, or they can change from year to year. They don't necessarily change from every year, but they do change them. And if you submit the wrong application, they're not going to accept it. So I'll talk about pardons a little bit more. So here's when you click on the link, petition to seal misdemeanor, this is what's going to come up. And they're all like fill in the blank PDFs. So they're easy to fill out. But I wanted to just point out where it says here, petition to seal misdemeanors. That's where you know what document you're working with. So you want to just make sure you're working with the right document. It says petition to seal misdemeanors or Act 346 or arrest or whatever you're trying to seal. Just make sure you got the right one. Okay, these are the sealing statutes. I'm not going to go into it too much because it's pretty confusing, but I will say if you're an advocate or if you're doing this for yourself, and absolutely if you're an attorney handling these, I would say just go ahead and read these. Here's the statute numbers here. There, it's very short, sections, and once you read it, you'll really understand what you're dealing with. So, First Offenders Act is a really special one because it's supposed to be, in my mind, it's supposed to be for your first felony conviction. Some people say, "Oh, it's for any case, including misdemeanors." I don't agree with that, and I'm not going to argue about it today. But for me, it's supposed to be for your first felony conviction because it restores rights that are taken away with a felony conviction. Okay. Act 531 of 1993 is a community punishment act. It still is in effect, and it does have some benefits to it. If so, Act 346, you have to be sentenced to at the time of sentencing. There's no way to go back and get it. Even if you qualified it for it and they didn't sentence you at the time, I really hate those cases because there's a lot of them. Act 531, there's case law that says you can be either sentenced to it or if you qualify for it, you can use it without being sentenced to it. And I have that case cited later in the presentation. I've had to argue about that before. You can use 531 twice. You can use Act 346 one time. And then, so if you, when did this act come in? 2013. Before 2013, if you weren't sentenced to 346 or 531, there was no way to seal your records in the courts. So when Act 1460 came into effect, it gives you a way, if you weren't sentenced under one of the record sealing statutes, there's now a way for you to seal those cases. So I'm going to talk about those going forward. But again, just go through, you can type in this ACA 1690 1401, and it'll take you right to the act and just read through it. Just read through all of them. So just I'm going to talk about generally about sealing different kinds of cases. For misdemeanors, there's no longer a waiting period. There used to be so the day you finished your misdemeanor sentence, you had to wait 60 days from then to seal your case, but they changed that law. That's no longer the law. You can seal it the same day that you get finished. Um, but finishing a sentence, of course, means paying everything off. If you had your driver's license suspended, which for drug case is usually for drug cases, there's a 6 month suspension. You have to get it reinstated. There is a reinstatement fee. It used to be $100. I don't know how much it is now, but you have to have your driver's license reinstated to have your sentence finished. And then any type of classes or community services, if you ordered anger management, theft prevention, any kind of classes, community services, sometimes ordered to offset like fines. But you got to have all that finished before you want to seal your case. Here's a list of misdemeanors that have a waiting period. It's normally a 5-year wait. But here's a list. Battery third is the one that comes up the most for me, and domestic battery third. Those two are going to have a 5-year waiting period from the completion of your sentence, not 5 years from the date you were sentenced. It's 5 years from the date you finished. So say you got 1 year of probation, but you didn't pay your fine. If you paid your fine today, if the day and you finished probation years ago, you paid your fine today, it's 5 years from today when you finish your sentence. I wanted to emphasize that. I have in here what the law is, and in my experience, I've been sealing records for in some form or fashion for at least 12 years. And so what the law says and what happens, kind of not the same. So it says you may only be able to seal one of these. That hasn't been my experience. But you might run into that. So I'll leave it in there. And then for misdemeanors, the Act 1460 that came in 2014, it changed the way misdemeanors are sealed, but it allows all misdemeanors to be sealed retroactive to the sentence. So prior to 2014, if your misdemeanor was way back when, it can be sealed. If it's new, it can be sealed. Because there were some issues about when you can seal felonies with Act 1460, but we've changed that, and I'll talk about that too. Okay, again, Act 1460, this is sealing felonies now instead of misdemeanors. Again, it created a way to seal cases that were not sentenced to expungement statutes or record sealing statutes. The dates matter. for these offenses as well, because for what they consider violent C and D felonies, and those are like aggravated assault, assault on family or household members, things like that, batteries, battery second, those have a 5-year wait. And again, it's from the end of the sentence. You have to wait from the end of the sentence. If you have a charge that's a non-violent C or D, so like a theft of property or something like that, possession charge, those are considered non-violent. So you don't have a 5-year wait for those. So it's important to know about those waiting periods. And for Act 1460 and all felonies, so the rule of thumb for felonies is you can seal two, and that means you can only have two. If you have three, you're going to have to go for the pardon. So you can seal one and one prior and no others. That's the judge I worked for and all the judges I've practiced. That's their, if you want to try it, you can try it. That's been their kind of mindset in my experience. They only want the one or the two. Okay, got a question.
Yes. How do you get proof of completion of probation for clients whose probation was supervised by private contractors like the Justice Network and not by the Department of Community Corrections? Those contractors are no longer around to contact. Would Department of Community Corrections have those records?
That's an interesting question. I've never heard of Justice Network, but I will say I've had a similar situation kind of recently. So in Pulaski County, in the past, there were two divisions that had their own supervision, probation officers, and now do no longer have probation offices with those divisions, and they were switched over to ACC, or who currently contracts to do that. And so ACC doesn't have its first division and fifth division, Pulaski County. They don't have those records. And so they don't want to give probation releases for those either. The judge's offices no longer have those records. You might be in a position that's difficult. You might have to just kind of explain. There might not be a way. The closest as you can get is my strategy or whatever, my problem solving. The closest I've been able to get is at least go to accounting, whichever court it's in, and you can at least show they have a zero balance if they have a zero balance sheet or something like that. That might help, but there are going to be some cases and that you're not going to be able to get that release because ACC doesn't have those records. I have a contact that I can't remember her name, and I don't want to touch anything on my screen, so I won't take it. But you can email me, whoever's question this is. I have a contact at ACC who's like the records supervisor, and so she can type it in. She can type your person into her system and tell you, and you can do that through email. Because in my experience, again, just my experience, calling these probation and parole offices, they're not going to speak to you as an attorney, as an advocate, as a family member. They want to talk to the person that was supervised only. They're not going to speak to you. So you might just have to work it a different way. I think her name is, I don't want to start calling names, but I can give you a contact who's the record supervisor at ACC. But yeah, there are going to be some situations. So in that case, I would just kind of try to work it out with the prosecutor. Like, hey, I couldn't get a release because of these reasons. They were supervised by somebody else that can't give a release, or ACC doesn't have the records or whatever, and try to work it out that way. Ask them what they would accept in lieu of their release. A lot of prosecutors don't even care if you have them or not, but Adrienne in Pulaski County, she's busy. She wants them. And I understand that. So I give them for her. And it helps to have them in your file, because if the prosecutor comes back and says, I see a balance here, but you have a probation release. Now, I've had this happen too. They don't care nothing about the probation release. They want something else. So just try to work out with the prosecutor, contact your prosecutor, and see what you can work out as proof that they finished. And if the prosecutor can't agree, then just go to a hearing and convince the judge. I wouldn't spend a whole lot of time trying to convince the prosecutor if they don't want to be convinced. Is there another question, or is this
Yeah,
the same one?
one
Okay.
more. Does the two limit apply to counts or cases, such as one case but convicted of multiple counts?
That's cases. That's cases. And even so, I have this later on in the presentation as well. One criminal episode counts as it's supposed to be one conviction, but in some jurisdictions you have where they have different prosecutors for different things. So say you had a case, you went on a spree one night, you sold some stuff, you beat some people up, you did a whole bunch of stuff. Some places have prosecutors that just do the stealing part. Some people have prosecutors that just do the violent crimes part. So they might separate them into different case numbers, but you might have to prove that, hey, this was all one night, it was all one arrest, it was all one criminal episode, is what we call it in the law. So it's supposed to be just two felony cases. So it can be two felony cases that had one case had 10 felonies in it, and if they were all sealable, then they can get sealed. And it can be another case that had one or two felonies, but it's only supposed to be two felony case convictions and not specific charges, just cases. Okay. All right. Man, okay. I'm gonna try to zoom because we're getting short. Sealing felonies. I talked about this. This is a list. This list is in the law. So if you read through Act 1460, it'll tell you. Act 1460 is really for C and D felonies, and drug cases. Anything else is not going to get sealed through 1460. Might not be sealed. Here, I've actually cited, and I apologize. I went through and started adding specific sections, but at the bottom here, you can type in this is section and it'll show. So I have some clients who say, they're trying to seal cases that cannot be sealed by law. And so when I um, advise them, I'm not the type of attorney that's just going to try to seal anything, because I don't take money for people like that. I'm not going to speak on people that do that, but I don't practice like that. If I see you're not eligible, there's no way your case is getting sealed, I'm not going to take your money. I don't have time to do that and go to court and fight and lose. So I usually write them a letter that says, hey, or I explain to them, I'm like, hey, you can't get it sealed for this, that it literally says you can't seal a manslaughter case in the law. And so I'll write them a disengagement letter and I'll cite the section of the law to kind of cover myself. I don't, again, I don't get into that. There's some attorneys who will take any case and try to seal anything and they know that can't be sealed. I don't agree with that. I'm not going to go into that today. Please don't do that. Okay. These are listed in the statutes as what they consider to be violent or sexual offenses. And that matters for what you're trying to seal. For the most part, you can't really seal some serious violent cases and most sexual cases. So for Act 531, there's no violence or no sexual cases for that. It has to be like a possession or a theft or something like that. Act 1460, also really not. So these more serious crimes, that's kind of the argument about, well, people shouldn't be able to steal the most serious stuff. You can't. You can't. So if you're out here dabbling, you're young, you're hanging around the wrong people, you changed your life, that's normally my client set. If you're, super hard into these really violent, serious crimes, those can't be sealed. Those aren't going to be sealed. So that's the argument for and against sealing cases. Let's see. Sealing arrests. Sealing arrests can get kind of tricky. But the rule is if there's no charges within the year of the arrest, you can seal it. The problem is that trying to seal them is there's usually no case number associated with it. And I have recently found that you can go through e-filing and open a new case. It's going to be a civil case, and I mean, it's kind of a headache. So, if anybody has any of those, I can help walk you through it. I've only done it once, and it was really hard. The clerk really, really helped me. It was a clerk in Boone County. But there is a way to open an arrest case, file it, MOF, original filing, through e-filing, but they'll assign it a civil case number, but they'll assign it to a criminal judge. You kind of have to handhold through some of these. If they're like, we've never done this before, I'm like, well, I've done it before. Let's learn how to do it. You kind of have to be kind of pushy because they might be like, well, we just can't seal that. Oh, yes, we can, and we will. So, there's a burden there. Normally don't have to deal with burdens on these arrests and stuff that don't really have any discretion. There's not really any discretion to seal an arrest. Yes, question.
Is there any difference with the process for federal cases or
Yes,
convictions?
absolutely. You have to get those from the president, and it's very hard. So yes, just Google. The last time I looked, they had actually taken the information off the Department of Justice website. But you can Google how to seal a federal case, and there's attorneys that handle those, but you have to go through the executive federal process. So it's through the president. Okay, sorry, you guys. I know we're getting short on time. I'm going to kind of zoom, but you'll get a copy of this presentation, my contact information if anybody has any questions. You can seal null pros cases a year after the null pros date. You can seal dismissals immediately. You can seal acquittals immediately. Um, that means no waiting period, except for acquittal for mental disease or defect. I've gone up and down. I've researched. I've talked to people who can't seal those. As far as I know. If you know different, please call me and I want to talk about it. Um, Filing, we've already basically talked about this. You file it in the same county where the conviction was or the arrest was or whatever, and you want to make sure to get it over to the prosecutor's office because they're going to say, I didn't know anything was filed, and your steady counting your 30 days. So you want to make sure they got it. You can literally call over to the prosecutor. This is what I do. I call to the prosecutor's office and say, hey, I filed a petition to seal on so and so. How would you like to receive that? Can I email it to you? Would you like it in the mail? And they'll tell me what they want. And again, that's the best way to do it. Is just give the prosecutor whatever they want, make it easy for them because they are standing in the way of you sealing your case. Okay, after denial, these are important misdemeanors. You have a 90-day wait from a denial, so you have to wait 3 months to file your case again. Whatever the denial was about, it can't just be we don't want this person to seal the case. It has to be they didn't pay something, they didn't finish something, blah blah blah. Felonies and some misdemeanors have a 1 year waiting period after denial, and there's a case of the citation for that. 30-day objection, we already talked about that. Okay, so I have to tell you this because it's there in the case law. There's a case that came down. I don't like it, and it kind of might say that there's no specific time period for a prosecutor to respond. That's horrible. I like the 30 days. So what I like to do is act like the 30 days is still the standard. If I haven't heard from them in 30 days, most prosecutors still go along with the 30 days. They'll file their response within but I'll just call and say, hey, it's been 30 days. Can I get a response in? I haven't had anybody cite this case that says I can take as long as I want, but it might be out there. Just don't tell them. Okay. The prosecutor has discretion whether to file something or not. Usually they'll file. Most people are trying to cut down their obligation in court. So if they don't have to have a hearing over this, they don't want to deal with it. Um, must have a hearing even if the prosecutor decides not to object. Those are the stars, because that's what the law says, but that's not my experience. I have had very recently hearings where the prosecutor says no objection, and the judge says we're going to set that for a court date. So can't get out of those. Unfortunately, the judge wants you to be there. Let's see. This is important. I'm gonna point it out. Slow down just for a minute. These are your factors for a felony hearing. Okay. These are in the statute. The statute's at the bottom. I'm gonna let you guys read through those because the next slide is what I want to talk, kind of harp on just a little bit. Hearing strategy. So if you get an objection, you find yourself facing a hearing. If you're pro se, you can look into hiring a lawyer for that. You don't necessarily have to go for the hearing by yourself. I will say a couple of things. Legal aid provides um, services for sealing records. And if you had a public defender, or if your client had a public defender at the time of sentencing, the Public Defender Commission seals records for free. So you can contact them over there. Megan and I are actually working on a free legal resources directory, and that information will be in there. But they do free record sealing for people that they represented in court. So you had to have been represented by a public defender in the original case. Okay, so hearing strategy, whether it's you pro se or you as an attorney, you're going to present your case in your best light using the factors on that previous slide right there. 5 factors again. Call your witnesses if necessary. I hate to report that I practice all over the state and down here in Southeast Arkansas, the judges want you to have a hearing over this. And that means call witnesses so you're not just arguing. Everywhere else, the judges, you'll say your piece, the prosecutor will say their piece, and the judge will make a decision. Down here, they want witnesses and whatnot, so you need to be prepared for that. Do not just show up down here thinking you're going to win on argument because the judge will be like, okay, call your first witness, and you're going to be stuttering. Okay, so call your witnesses if necessary. If you're coming down here, Southeast Arkansas, Deshae, Chico, Drew, Bradley, Ashley, call me and we can talk about it because they do them district court and circuit court. One of the best pieces of advice I've ever gotten from another attorney: if you win, shut up. It's time to stop talking. Don't, well, judge, I had a whole list of stuff that I, nope. If the judge say, well, I'm going to grant that, it's time to stop talking. Okay. You don't say another word. You show your prosecutor a copy of the order. Here, would you like to see the order? You ask that judge if you may approach with your order. You have it in your file. You take a copy of your proposed order with you. Don't expect the judge to print it out for you, the clerk, or nobody else. Be prepared, take it with you. You ask the judge if you can approach the order, you give the judge the order, you go back to standing behind the podium and you ask if you can be excused. Don't say anything else. Oh, that was easy. Oh, that was hard. Don't say anything. Shut up and leave. Okay? Best advice I've ever gotten. Stop talking when you win. Okay? So, and then once you're going to leave the order with the judge, and then you can contact the clerk to get a signed and file marked copy of your order the next day, later that day. However, just call the clerk and say, hey, my case got sealed. Can I get a copy of that? And they'll tell you what you need to do. Stop talking if you win. Okay. I see it's 101. Okay, here, I'm wrapping it up.
Yeah, take us
Okay,
back. I
so
have it to 115, so you're
okay.
good.
I know you, and there might be questions. I just don't want to, I don't even know how many slides I have left. I just don't want to, you know, leave, have stuff left over to talk about. So, um, Act 1460 came into effect in about 2014. At that point, you could only, I told you about the case law where you can seal misdemeanors from any time. At the time this act got enacted, you could only seal felonies from 2014 going forward. In 2021, Act 341, and some people don't know about this. This is why I just pointed out, because some people have been doing this a long time. They don't know when stuff changes. Act 2021, it changed everything because now you can seal a felony regardless of when it happened. There's no 2014 and beyond. You can seal your 1995 felony if you didn't get 346 or 531. It's now eligible to be sealed under Act 1460. There's no enactment period. Sorry, my kids are arguing in there. If you guys can hear them, I'm so sorry. And then the other thing that Act changed is now prison sentences can be sealed, because before, way back when, you could only seal probation sentences. You couldn't seal prison sentences, but now through Act 1460, you can seal prison sentences as well. Again, it has to be the one or the two. Some people get sent to prison on their first felony. Absolutely. I've seen it many times. It's unfortunate, but it happens. So it has to be the one or the two, no more. First Offenders Act. Okay, here's some stars. It should be automatic if it was prior to 1995. I don't find that to be the case. It used to be your probation officer would get it sealed for you as part of coming off of probation. It might have happened, it might not have happened. So if somebody told you it would just automatically be sealed, don't ever believe that. Check into it for yourself. Probation must be longer than a year. Star, star, star. I've had longer, less than a year be sealed under First Offenders Act. So that's what I'm just saying. The law says what it says, but in practice, it doesn't necessarily happen that way. You must specifically be sentenced under this law, and it can only be used. It's really big because if you can only use the statute one time, and if you try to use it more than once, you're going to get a felony. So that's why I said earlier, somebody had a misdemeanor sealed under this statute. I went back to the misdemeanor judge, asked them to amend that to be sealed as a misdemeanor, and then used Act 346. A person got sentenced under Act 346 for a subsequent felony, and so it was available. That's very creative. Not a lot of people are in that position, but do not try to use it more than once. Offenses that do not qualify, star, star, star. I've had any number of offenses. If a judge agrees for you to be sentenced under Act 346, it's just gonna happen. Like, prosecutor can fight it at a hearing. ACIC, if you give them an order that was signed by a judge, it doesn't matter what's on there. They're gonna seal whatever it says. So some stuff happens. Like I said, the law is what it says. It doesn't always happen that way in practice. Disposition is deferred sentence without adjudication of guilt. So it's supposed to say, what that means is guilty conviction is not supposed to be entered. It's supposed to say deferred adjudication. Star, 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 because some courts don't care. They're going to put you as guilty. I have a person down here right now who got Act 346. It says guilty on her sentencing order. It says guilty on Court Connect, and she cannot get it changed because they're just being hateful. And so I've been trying to, problem solve with her, but that happens. Okay, so when the case is confident, the special part about these are these two things. You're not ever considered guilty, okay? And so the disposition that it's going to show after your case is sealed is going to be dismissed. It's not going to show up as you were guilty. And then another thing is here we are. Since there was no conviction, your firearm rights are restored, and the ability to become a guardian is also restored because you can't be a guardian with a felony conviction. I mean, you can, you have to try really hard and argue and show the judge why. But so those are reinstated. So I know that was a question from earlier. That's Act 346 only. That's why Act 346 is special. That's why people want it, and that's why people don't want people to have it because of gun rights and stuff like that. Here's the more side about that. Some prosecutors don't like it because they can't to sentence under that act because it doesn't count for conviction for conviction purposes. The more convictions they have, the more grant money they get. I don't agree with that. I don't have time to go into that today. It also restores gun rights. Some prosecutors, because of the charge or because whatever, don't want people to have gun rights. I do understand that, but the law is the law. Um, it must be ordered at the time of sentencing, and you might have to search for it to have proof of it. And you might have to look on the ACIC report. It'll show at the very top if it'll say 346 ordered or 346 or something like that. It'll say if somebody's been sentenced to 346, it might be in the sentencing order. It might be on the judge notes on Court Connect. It might be on the probation conditions. You might really have to find it. But for the most part, my experience is a person remembers being sentenced under Act 346. They'll remember First Offenders Act or they'll remember 346. They'll be like, hey, do you remember First Offenders or Act 346 or anything? And just kind of go from there. Act 531, I've kind of talked about all this. You can use it two times. For target offenses, and target offenses again are not sexual, not violent. And then I'm trying to find where's my there's a exception for Y felonies, and those are drug cases. So there's some drug amounts that just having that amount is a Y felony in itself. Those can be sealed under Act 531. Here's the case that says you don't have to be sentenced under Act 531 as long as you meet the requirements. So that means you had the right kind of charge. Uh, and the difference is there's no waiting period under Act 531. So it depends on the charge. If you have the 5-year wait under 1460, if you don't have it just depends. You have to do some analysis there. It may not be retroactive. So this is one of the ones in Act 531 came about in 1994. You might not be able to use it. I've never had this come up, but just for teaching it. If you're trying to use it for something that's pre 1994, might have a problem, maybe not. And it can be used twice. So if you have your two felonies, you didn't get 346, they both qualify for 531. You can file under 531 for two different cases. All right. ACIC drug court, they don't know. Drug court, a lot of drug courts handle their own sealing. They'll tell you how to seal it or how to do it or give you some instruction for that. So just go by whatever they say. You can ACIC will correct your first offender part as a conviction or not. It's Court Connect, the people that handle Court Connect that might not check that might still keep it as guilty on Court Connect instead of deferred adjudication or deferred sentence or whatever. And something also to know, mainly for practitioners, they take it a little bit easier on pro se people. ACIC forms from the website, y'all. I'm so sorry. They don't have a 2-inch margin, so the court clerks might reject it for not having that 2-inch margin, and you might have to use a cover sheet. Well, you just Google civil cover sheet in Arkansas and just use that one. And the courts that I have experience with that do that are Ashley, DeShay, and Pope County. It might have changed, it might have not, but they normally want a cover sheet in those courts. Okay, closing out. Once you get your file marked order, you need to send it to both of these ACIC addresses. It's hard for me to keep them straight. There's two ladies that seal records at ACIC. One does felonies, one does misdemeanors. I don't know whose is who, so just send it to both of them because the two ladies check two different emails. And let's see, ACIC has 30 days. There's the phone number to call, and they'll say, ACIC, how can I direct your call? You say, may I have criminal history, please? And then whoever at criminal history, you can ask them about has it been sealed or whatever. And at the end, when they tell you it has been sealed, then you email Miss Susie again, and you get a corrected copy of your ACR file. Pardons, I'm sorry, make it very quickly. Pardons, you have to, if you have more than two felonies or some charges, you have to go for a pardon. That's uh, fire, even if you got your felony record sealed, in most cases, it doesn't, Act 531, Act 1460, that doesn't restore firearm rights. So you got to go through a pardon for that. Commutations or time cuts. I'm working on one of those right now. You got somebody sentenced for forever, and you're trying to get them out, you go through a pardon application for that as well. Again, you can Google Arkansas pardon application. I have the link for the most recent one, but going forward, if you want to make sure that's the most recent one you're looking for, it says DOC, that's Department of Corrections. They put their own pardon application out. It's what the important thing to know is much harder process. It takes much longer. It takes a whole year to even get any results. And you need some different certified documents right here in the list. It's on the pardon application, what you need. You just call the court where you got sentenced and get certified copies. That means the clerk has to flip it over and sign them to show that's an official court document that hasn't been changed. Pardons require letters of support. The more the better. This is always the hardest part for me, is to getting all the letters and getting them right and getting them all collected, and people straggle and stuff like that. So just know going in that the letters, you focus on that first because that's going to take the longest. My advice to everybody is make your first application your best application, because you cannot apply again for a pardon from 5 years of your date of denial. And they keep pushing that out, because at first you could only apply after 1 year, and then you could apply 4 years after the date of your application. And now they're up to 5 years from the date of your denial. So the pardon application is really long and it's very difficult. The good thing about it is you don't have to completely reapply again. Everything will be kept on file. So every pardon application you ever put in will always be kept on file. So my advice is you don't have anything to lose. Just keep trying until you can get it. Okay. The two important things to know: the decisions go first to the parole board. They will give you a decision. The decision is either with merit or without merit. Their decision is not binding. Okay, because so from there it'll go to the governor's office. Whatever the governor's office decision is the final decision. So the parole board could say without merit, we don't agree with your pardon, and the governor doesn't have any weight on her decision. She could grant the pardon either way. Um, the important thing to know, is not in here, but I will say it that the governor has 240 days, which is roughly 8 months, to make a decision. If she doesn't make a decision in writing within that time period, the 5 year wait is waived. You can automatically apply again. Okay. So that's important to know. You got to keep in touch. You got to keep track with those dates. It's not a legal process and you don't need an attorney. Now, the pardon supervisor in Pine Bluff, in the institutional release office, her name is Carla Whelan. She is a very nice person. Easier to email her. You can get her on the phone, but she will answer absolutely every question. If you have questions about the application, you need to know somebody's prison ID number or SID, whatever you need to know. Did they have any disciplinaries? She can tell you all that. She's very, very, very kind. Please don't mess her up for the rest of us if you have to deal with her. But she's very nice and she's very helpful. So Carla Whelan, if you need to have any questions about pardons. Sorry, I had to rush, and that's everything I have today. So thank you all very much. I hope that's helpful. You can contact me, whether you're an attorney, pro se, advocate. I'm happy to answer questions. It's easier to get me on text or email, but if we need to make a call, we can set one up. Thank you guys so much.